You have a quorum, Madam Chair.
Thank you. We will start with our docket. I'd like to first turn to bills that are identical, something that passed the Senate. So the first identical bill is House Bill 2157, has to do with the use of jurisdictional compacts and criminal history record checks. It's identical to Senator Heat's bill, and it did pass the Senate 39-0. So since it was identical, I think except for microphones on.
Ayes 10, no 0.
Okay. The next identical bill, patron is Delegate Head, House Bill 2344, Adult Protective Services referral to local law enforcement, and it's identical to Senator Pillion's bill, 1421. Senator Pillion's bill passed the Senate for second. Second.
How in the world that bad?
Okay, colleagues.
Good thing it's head and not pillow.
But Delegate Head, it's a good bill. That's why I'm voting for it. I want you to know that.
Ayes 12, no 0.
Stamp of approval already.
Okay, now the next bill is identical. It's a bill that actually was seated in rehab. This is House Bill 2412. Is Delegate Campbell here? Do you want to make a very brief statement? It's identical to the bill that go ahead.
Good morning. Thank you, ma'am. HB 2412 is regarding the conditional release of geriatric patients. I'm not patients, excuse me, prisoners. And what this does is these prisoners often are what we call dual eligible for parole under the discretionary parole as well as the geriatric release. And it just combines those two hearings that are identical into one hearing.
Thank you. Anybody have any questions? Do you have any speakers with you?
No, ma'am.
I'd like a motion, please. To PBI. Okay, substitute motion has been made to PBI, and there was a second. We'll hear that substitute motion first. The clerk, please open the roll.
Ayes 8, noes 4.
Thank you,
Bill
ma'am.
has been PBI. Okay, colleagues, let's turn to page 3 of our agenda. Delegate Head. Is Delegate Head here?
I am here.
Welcome. Okay, so House Bill 1846. As I understand it, it is close to Senator Donovan's, but we probably want it to go into conference.
No, ma'am, we actually have a substitute, I think, for
Okay.
you this morning that will put them in the exact same posture.
Okay.
So,
Do you have the substitute before us?
I believe that you do.
They made some changes.
It's been a work in progress all the way through, and we finally got everything on, everybody's all on the same page now, so we,
So we will have to adopt the substitute, but all those in favor of adopting the substitute signify by saying aye. Aye. Okay,
And if you-
please explain the substitute.
the basic changes in the substitute from the bill as it left here, with these amendments now, we have that no practitioner can issue a written certification while the practitioner's on the premises there, so you can't have the doc on site. There can be no relationship with the prescribing referrer, and there can't be any advertising on the part of the dispensary that they will allow you to do this there, or that they will direct you toward any one. So it just makes it clear that what we're trying to allow here now, it makes it very, very clear that if someone has certification, it's expired, they get to the dispensary, currently they're not even allowed in. Now they can be allowed onto the retail floor and can actually call their provider from there without having to leave, go out to the car, call them, wait for it to be faxed in, and then come back in. We can just speed the process up, because this has happened several times, particularly in rural areas, and it'll just alleviate, allow people to get
the telehealth tool.
Exactly, but it eliminates what we wanted to avoid was being able to say, hey, just stop on by and we'll get you certified right now. That's not what we wanted, is to turn it into that kind of an environment. So we've gotten this very clear, and I think everybody's comfortable.
Second.
Okay, colleagues, a motion has been made and seconded. Will the clerk please open the roll?
Ayes 11, noes 2.
Okay?
And Madam Chair, I have another bill. Would you like me to wait until it comes to that point in your block, or?
No, go ahead while you're with
Okay,
us.
we have 1768. And there is also a line amendment that we need to add to that.
Yes,
Line amendments on line 74, after the word center, to insert recognized by the National Children's Alliance. And then on line 74, after interview with a, insert recognized. So that now lines 73 to 76 should read, if a local multidisciplinary team has determined that an interview by a child Child Advocacy Center recognized by the National Children's Alliance is needed, and an interview with a recognized Child Advocacy Center within the jurisdiction cannot be completed within 14 days, the local department may facilitate the interview with a recognized Child Advocacy Center located in another jurisdiction.
I like this bill.
So,
Second.
Well, Delegate, you're doing just fine. Okay, motion. Yeah. I was going to say, colleagues, motion's been made, and there's a second, correct, to adopt the amendments? Okay, all those in favor of adopting the amendments signify by saying aye. Aye. Okay, I'd like a motion. Okay, all right. Now, would the clerk please open the roll?
Ayes 14, noes 0.
very good. I appreciate the kind response from the committee this morning. Thank you so much.
Thank you. It's a nice way to start your weekend. Okay, let's see. Who do we have next in the audience? Delegate Bell, you were here early. Colleagues, go to House Bill 1976.
Ma'am, good morning. I understand that there is a Senate bill which is close but not exactly the same, and I've talked to Senator Deeds, and our expectation is that you will conform this bill to his language, which has already been advanced out of your body, and then we will try to figure this out in a conference. But that's
So, motion is to adopt the substitute, which is Senator Deeds' bill. There's a second. All those in favor signify by saying aye. Aye. Now I need a motion to report as amended. Is there a second? Okay, the clerk, please open the roll.
Ayes 14, noes 0.
Good luck in conference.
Thank you, ma'am.
Thank you, Delegate Bell. Okay, is Delegate, let's see, I don't have that down here. Delegate Ballard? Please come forward.
Good morning, Madam Chair, members of the committee. Happy Friday.
Colleagues, it's House Bill 1458.
Yes, ma'am. So House Bill 1458 deals with conditional release of geriatric prisoners. Pretty straightforward. The bill actually expands the list of offenses committed on or after July 1st of this year that would make a geriatric prisoner ineligible for parole. And that includes certain violent felony offenses, which are enumerated in the bill, as well as certain second and subsequent felony violations when such offenses were not part of a common act transaction or scheme while the person was at liberty. The newly included offenses just by way of example, are first-degree murder, rape, aggravated malicious wounding, abduction with intent to defile, committing an act of terrorism, and using a sawed-off shotgun in a crime of violence. Also, by way of example, offenses that are not included under the bill: drug sale, malicious shooting into an occupied dwelling, grand larceny, or burglary with intent to commit larceny. Happy to take any questions, but the bill's pretty straightforward.
Okay. Colleagues, do you have any questions? Senator Morrissey.
Morning, Delegate.
Good morning, Senator.
Delegate, what is the rationale behind keeping a 70-year-old who has served 30 years in prison, has renal failure or has cancer or some type of heart disease, and it's costing the Commonwealth $250,000 a year to keep him, and he's in his last 2-3 years of life, maybe months? Why would we not want that person to go home, save the Commonwealth money if that factor is attractive to you, but allow him to die at home with his family, given that he's served 3 decades? I'm trying to understand why we wouldn't do that.
Certainly. Madam Chair, Senator Morrissey, this particular bill was brought to me by a constituent based on a personal situation in her life involving an ex-husband. As to your particular question, I think what the bill is trying to do is recognize that for certain violent offenses, we want to keep those committed of those offenses in jail. And so it doesn't have anything to do with whether you're terminally ill, a geriatric prisoner. It's an acknowledgement that we want to punish those to the fullest extent of the law.
Follow-up question, final question.
Senator
So,
Morrissey.
and you're certainly entitled to this belief, and I just want to make sure that I understand you. You believe that if somebody has served decades in prison, perhaps has a stellar record, and it's been a violent crime, and that even though that they're in the end stages of whatever disease you want to put in, that we should keep them, and even though they're costing the Commonwealth a fortune, that, and you're right to believe this, but you believe that person should stay in that prison cell until the day he dies. Is that right?
Madam Chair, Senator Morrissey, if you're asking as to my personal belief, yes, that is my personal
Fair
belief. Yes, Senator
All
Morrissey.
right, thank you.
Okay, well, there may be some philosophical differences.
Madam Chairman.
Who just called me? Okay, Senator Cosgrove.
Thank you, Madam Chairman. I just have to have a little bit of disagreement with my friend from City of Richmond. Basically, I hope that we're not going to equate saving the Commonwealth money to making our citizens safe. I mean, this is, I think this bill is well thought out. I think I know where it's going, but I hope we don't get to the point in this body where money is the driver and not what's right and just.
Madam Chair. I hope we always go for policy. Senator DeStep and then Senator Boysko.
I just wanted to respond to what he said.
Madam Chair, I'll defer, and then I'll follow up
Okay,
at the
Senator
end.
Boysko.
Madam Chair, we are among the lowest states of recidivism in the entire country. So, and the current policy we have now allows certain individuals to come home who are included in this. It is not, we're at the bottom of the list of people who are readmitted. So I just take a little exception of my colleague, what he just said.
Senator DeStep.
Madam Chair, and I'm just going to sum it up and then I'll make a motion at the end. Charles Manson died in prison. I'm glad he did. Madam Chair, there's some child sexual predators that I helped put in prison. 2 of them have passed away, and I'm glad they did. There's a couple of more that rape babies, and I'll watch it, and the day they pass away in prison, I'll be glad that they died in prison, and I'm glad they're not out amongst us to create any further havoc in our society. With that, I'd like to make a motion that we report this bill.
Is there a substitute?
Substitute motion. I move that the bill be passed by indefinitely.
Okay, substitute motion has been made. It takes preference. It's been seconded. Will the clerk please open the roll? It's a PBI motion.
Ayes 9, noes 5.
Your bill's passed by indefinitely.
Thank you, Madam Chair, members of the committee. Have a good day.
Thank you. Delegate Bennett Parker. Colleagues, it's House Bill 1730.
Thank you, Madam Chair. I have a substitute amendment to offer.
It's yes. I see that this is House Bill 1730. A motion has been made to accept the substitute. There's a second. All those in favor signify by saying aye. Aye. Okay, the amended bill is before us. Go ahead.
Thank you, Madam Chair. The substitute encompasses the original purposes of the bill, but addresses concerns to clarify that when someone has not yet completed probation or parole, ABC will consult with their officer before the issuance of any waiver. The bill relieves businesses and ABC of having to go through that waiver process for those who are at least 2 years post-conviction and have completed any probation or parole. Currently, licensees can apply to ABC for hiring approval for any employee, but this can be burdensome and a process they don't have time to wait for at a time when, as you know, restaurants and other businesses are facing severe staffing shortages. Businesses should be allowed to interview candidates and making the hiring decisions that are right for their businesses. They retain the right to use their discretion in hiring or not hiring employees. This bill just gives them more flexibility. The substitute has the support of ABC and industry stakeholders. Thank you, Madam Chair.
It's a pathway forward for offenders who have done their time and could in fact serve.
Madam Chairman.
Okay. Yes, Senator Servell.
We're not able to get the substitute to come up electronically.
Here it is. It's 4 lines.
Oh, okay.
Madam Chair.
Senator Morrissey.
Thank you. I want to congratulate the delegate for bringing this bill. This reminds me of a DPOR bill that we discussed in here that encourages people who have had criminal convictions to get back to work so that they become productive and purposeful and not a drag on society. So the fact that the restaurant can hire this person irrespective of the previous crime, having shown a window of good behavior, I think it's a great idea. Thank the delegate for bringing it.
Thank you.
Okay, a motion has been made to report the bill as amended, and there's a second, and I have somebody who wants to comment. Senator DeStefano.
Madam Chair, I'm still trying to pull this up online. There's more than just this. That's the substitute, as council's telling me, but it's not coming up online at all. The other pieces. All right. Now, I want to support the bill, but I don't like voting on something I haven't read. So
I will
push it through. I'm happy
I
to
will ask
abstain.
Mr. Maid. Yeah. Why don't you walk us through it? That might be easier.
Madam Chair, so the substitute, it does a couple things. A lot of it is technical in nature, kind of a little bit of a reorganization. One substantive change that it makes is it clarifies that if the person being hired is on or had probation and parole, that and that they're on it and ABC approves for them to be employed, that their probation and parole officer is consulted by the authority prior to the hiring. So it basically modifies the language that you will see in subsection B of 4.1-225, and then the language in C remains the exact same as it is in the current bill.
I actually think the substitute adds some clarity. Okay, colleagues, the motion was made to report the bill as amended, and it was seconded. Are you comfortable voting? I'll ask the clerk to open the roll.
Ayes 14, no 0.
Thank you, Madam Chair.
Okay. Who else do I see? Delegate, let's see, Delegate Adams?
Is this wrong, Adams? I'm sorry. I just realized there's another Adams.
There's another, I was actually looking at.
You wanted the Donna.
I was actually looking at the lady.
Good morning.
John Adams is, okay.
Good morning, Madam Chair, members of the committee. HB 2368 comes at the behest of medical cannabis patients and clinicians, and it does 4 things to help them. It requires complete and accurate labeling of products and accessibility of this information on the dispensary's websites. It requires dispensaries to maintain an adequate supply of low THC and CBD-rich products. It allows at the patient's request and provider's discretion to place a designated agent on the medical certification. And it requires the active ingredients rather than the street names be placed on the prescription monitoring program form. And I'm happy to explain the rationale for any of those should it be needed.
This is a really helpful bill. It's really a labeling bill for our medical cannabis. Does anybody have any questions before? Okay, a motion has been made and seconded. I guess the chair will be quiet and ask that the clerk open the roll.
Ayes 14, noes 1.
Thank you so much.
Thank you, Delegate. Okay, Delegate Rome.
Good morning, Madam Chair, members of the committee. I've got two bills, so I'll present HB 2025 first, if you like.
HB 2025, got it.
Yes. Thank you, Madam Chair. So, Madam Chair, members of the committee here, HB 2025 would direct the Virginia Department of Social Services to develop and keep updated an information sheet on the Federal Supplemental Nutrition Assistance Program, aka SNAP, and distribute this information along with SNAP applications to the Virginia Department of Education. The DOE would then ensure that the information reaches all students in primary and secondary public schools in the Commonwealth at the beginning of their school year. And we worked on the language with this with DSS and DOE. And the bill would ensure that those students and parents that may be unaware of their own SNAP eligibility, as well as the benefits provided by SNAP, including automatic eligibility for free and reduced meals, would actually have the information provided to them. So with that, I'm happy to take any questions.
I expect the schools are fine with this.
Schools love it.
Okay, great. And I know Mr. Ayers was in the audience, so I expect DSS is fine? Okay. This is a good bill. Colleagues? Okay, a motion has been made and seconded to report. Clerk, please open the roll.
Ayes 15, noes 0.
Ayes 15, no 0. Okay, let's move to, is it 2029?
Yes, Madam Chair. So, Madam Chair and members of the committee here, HB 2029, this says two things. So first, we seek to align the terms of service for the Public Guardian and Conservator Advisory Board. And the bill equalizes the terms for all members of the advisory board to 4 years, because right now they're all not aligned. And that's consistent with other DARS advisory boards. The second change would strike outdated and unnecessary language. And so what this part does here basically is the bill would align current practice when notifying the courts with state code. When the current language was drafted in 1998, it was envisioned that there would be a different procedure in mind. The guardianship programs were directed to notify courts when they reached maximum caseloads, so courts would not refer additional clients when the program was beyond capacity. And basically at this point, we're trying to make sure that existing practice actually lines up with the Code of Virginia. And with that, I'm happy to take any questions.
Okay, did you bring any speakers with you?
Nothing I'm aware of, but if anyone
Looks
wants
like
to.
it's in good shape.
Yeah.
Colleagues, do you have any questions? Okay, motion has been made to report and seconded. Anybody wishing to speak to that? Seeing none, will the clerk please open the roll?
Ayes 13, noes 0, 2 abstentions.
Thank you, Madam Chair.
Your bill reports. Okay, colleagues, we're moving along here. We've got Delegate Carr, and then I'll go to Les Adams, but Delegate Carr and then Delegate Adams. Delegate Carr, colleagues, it's House Bill 1744.
Thank you, Madam Chair and members of the committee. HB 1744 aims to decrease the burden of the foster and adoptive families by ensuring that a standardized template for home studies is established, and clarifies that the agency shall provide the home study and other required documents to the family to take to another agency when the family requests this. Further, it creates a mechanism to establish reasonable compensation for the initial approval agency when the family transitions to another agency. And I believe DSS is here to clarify any questions.
This bill has been in the works actually for several years. I know it was a recommendation from the Commission on Youth, and I am glad to see that this bill has
Thank you.
gained such consensus. Mr. Ayers, are you fine with this bill from DSS?
Yes, ma'am. I'll leave it to you unless you got questions.
Okay. Colleagues, do you have any? Okay. Motion has been made to report and that was seconded. Will the clerk please open the roll?
Ayes 15, no 0.
Oh, it even reports and gets on the consent agenda.
Thank you, Madam Chairman, members of the committee.
Thank you. Thank you. Okay, Delegate Les Adams.
Good morning, Madam Chair.
Good morning. It's House Bill 2018?
Yes, House Bill 2018. Chairman Favola and members of the committee, this is a bill that has bipartisan support. It does not come on the recommendation of the governor's administration, but I understand the administration supports the bill. It's also supported by the Sheriff's Association. It was developed after discussions that I had with my local sheriff, who, following one of the horrific school shootings that makes national news, he came out of a CPMT meeting and realized that some of the information that he received that may be very relevant to a school where he could share with a school resource officer as a preventative measure, he could not under the very tight confidentiality requirements of the Children's Services Act governing FAP teams and CPMT teams. And so the legislation that we developed is a very limited expansion of the confidentiality provision, basically to say that following the instruction that the information shall be confidential. It says, however, if team members obtain information from which the team determines that a child poses a threat of violence or physical harm to himself or others, the team may share information with local law enforcement or the applicable threat assessment team that's already established pursuant to this other section of the code. And that is the only language of the bill.
I have a question. If the information is shared with local law enforcement, is local law enforcement obligated in any way to keep that information within its agency and not share it in a public venue or any other way?
There's no additional directive on law enforcement in this bill. If there's other
Are there other
strictures on them, I'm not entirely sure.
Okay, let me direct my question to our counsel. Mr. May. Okay. Okay. Senator Morsi, maybe you have a response.
Oh, no, I'm sorry. I don't. I wanted to piggyback on your question, but I will defer until.
Yeah, I think Mr. May wants to check a statute. The question was, once the information goes to law enforcement, is law enforcement obligated, I'm sure it's in another statute, to contain that information and not share it further in a public record or?
Madam Chair, let me address that. Here's the beauty of the bill. It requires two agencies that heretofore were not allowed to now share that information with law enforcement agencies. Then we get to your question, what about the law enforcement agency sharing it with another? This bill doesn't address that, and that law enforcement agency can still hold its own parochial control over the intel or the information and not share it with somebody else. But I don't think the delegates' bill has the capability of going that far, but it certainly solves a problem.
Right.
And
I just wanted to make sure it didn't create another problem, but I agree with you, it does solve a problem. And I know the lack of access to information among agencies that do serve our community and do protect us has been a problem, and I do acknowledge that. So I believe I had a note from Valerie LaRue with the ACLU, and she wanted to. Virginia Poverty Law Center. Okay. Ms. LaRue, would you like to come forward? I just want to make sure everybody has complete information on the bill before you vote.
Thank you, Madam Chair. Valerie LaRue from Virginia Poverty Law Center. And I'm sorry that this bill was actually not on my radar until recently. I did share my concerns with Delegate Adams by sending an email and chatting him about it this morning. So in 2021, the Commission on Youth studied the issue of information sharing between social services and DJJ. Because of the same kind of siloing that Delegate Adams has addressed. And the Commission on Youth came up with recommendations on how to put guardrails around that sharing. So specifically, they had to come up with a information sharing agreement, and that agreement needed to be reviewed by the Attorney General's office before information could be shared. So I think the concerns that the committee's questions have already raised are legitimate ones. What happens to that information, that confidential information that currently can't be shared? There may be a legitimate reason to share it, as Delegate Adams has raised, but how do we know that that information doesn't escape those boundaries? And so I would ask that either the committee adopt the language, which was from Delegate Bell's bill, and I think Senator Mason, did you carry it as well? It might have been Senator Marsden. Someone else on the Commission on Youth, I think, carried it. That was passed in 2022, or put some other restrictions like requiring the threat team to file a petition with the JDR court and ask for an emergency order to share the information if an emergency exists. Thank you.
Madam Chair.
Senator Morrissey.
Ms. LaRue, just one question. Can you give me one example of where there would be a piece of information that CPMT might have that they would not want to share with the Family Assessment and Planning team, or vice versa? Because on black and white, it seems such a practical bill. What would you not want to share?
So this is information where a threat of harm to others or a threat to harm for self has come to the attention of either of the FAP team or the CPMT. And those teams exist purely to decide what services to give to a youth or a family. They therefore sometimes have access to, for instance, psychological examinations of the child. And so if one of those exams includes fear of a threat, then my understanding of this bill is that would enable that team to then go to the police and say, this child poses a threat. But this bill doesn't say that that's the only thing they can share. They could say, oh, here's a psych exam of this child. And then that psych exam is basically, out in the wild. We don't know what happens to it after that. And so that's my concern, is that sensitive, there's a reason why we have these confidentiality statutes, and that's because we know that children can have psychological problems and behavioral problems that we are trying to solve while they're children before they get to be adults. And we don't want those, once they've been solved, to follow that child into adulthood where they could harm them, or even when they're children, harm them in terms of how they're viewed in the community. Thank you.
Sir, did you want to speak to the bill?
Yes, thank you, Madam Chairman, members of the committee. Scott Reiner, the Director at the Office of Children's Services. I just come to confirm Delegate Adams' statement that the administration supports the bill, and to answer any questions you may have for me.
Okay, there seems to be a speaker behind you. Chair.
Madam Chair.
This is Elizabeth Hobbs. Maybe the administration spokesperson should stay around. Senator Rouse.
Thank you. Can someone speak to the school to prison pipeline and what this would do to it?
Madam Chair and Senator Rouse, I would say, yeah, when I'd asked some of those who had initial concerns in the House, what those concerns were, that's was one of the comments that was initially expressed was, well, we don't want to get in the in the practice of criminalizing mental health.
Right.
So my explanation, my answer to that was, there's no criminal component to this. This is clearly a matter of there's nothing further, no criminal action that takes place. We're talking about situations where the public may say after a horrible school shooting, geez, why didn't someone know or take precaution about this individual that is seeking help? And so I think the confidentiality provisions are, we have these local government institutions in place to provide services for children, families that are in need. And so we don't want to spread that information about the child, the family. Should be kept confidentiality. But from a public safety perspective, when there is an imminent threat of harm to the community, it shouldn't be so confidential that a sheriff couldn't tell his school resource officer, this person you need to be on the lookout for. They come to the school. That would be my argument as opposed to that, and that there is no concern about a school to prison pipeline with this legislation.
Senator Ross?
Madam Chair, if I could follow up?
Yes.
Thank you. So when you look at, my concern is when we talk about identifying children who may pose a threat or not, and passing the information on to law enforcement, you have to look at the numbers in which black students, especially black students, 3 key points and I'm reading this right off the website. The school to prison pipeline, exclusionary discipline, referrals to law enforcement, and sentencing to juvenile correctional centers. And so oftentimes when we know that there is a lack of representation as far as in our teaching, and throughout our teachers in our schools, where black students are oftentimes suspended at higher rates, my concern is identifying children who may need just either mental health or more resources in helping curb behavior, rather than labeling and then whether suspending them or referring to law enforcement, where those records, and it may not be a record on file, but locally, can follow a student through out their time in K through 12 education. So I have real concerns when it comes to this. And so when I speak of school to prison pipeline, I wanted you to address that. Obviously, if there's imminent threat, I think no one in this room wants another school shooting. I certainly don't. I've been part of 2 mass shootings myself, indirectly. It's horrible. But I like to understand how we're not trying to make matters worse when it comes to identifying these children.
And Madam Chair.
Yes, go ahead.
Just to respond briefly, I would simply say, there is no disciplinary component to this legislation. So there is, in terms of no action to be taken, no criminal referral, no school discipline. This is simply a sharing of information from a pure preventative measure. So any other policies that are out there that govern the action of schools, that govern the actions of police in terms of what they must develop before they can take any action, those all still remain in place. This is just allowing that information about a particular person who may pose a threat, so that there can be awareness.
Colleagues, I'm going to ask, there's been Elizabeth Hobbs with the Sheriff's Association has been waiting to speak. I'm going to ask her to come to the podium, then we're going to take a few more comments, and then we're going to wrap this up. Okay, let's let her speak, and then I will turn to you, Senator Servell, and then to you, Senator DeStefano.
Good morning,
Senator Mason.
Madam Chairman and members of the committee. Elizabeth Hobbs from the Virginia Sheriff's Association. We do support the bill. I think there was a question earlier about obligations of law enforcement to maintain juvenile confidentiality, and that is under 16.1-301. That already exists and is not in any way abrogated by this particular bill or amendment. There is already an obligation for law enforcement to maintain the confidentiality of the records and information of juveniles.
I guess that was the answer to my question. Colleagues, I would ask if we defer to Senator Servell for a moment. If you have an amendment, though.
I have a question
Senator Mason.
either for the Sheriff's Association or the patrons left. You keep just referencing school resource officer. You're going to share this. So I've sat through one of these, and I only sat through one because they had to bulletproof confidentiality. I mean, it must have added hours to this group's effort just so I could see what they did, right? So the confidentiality here is of the utmost importance. What could you do with the information? Could you, obviously, Newport News is the center of this discussion. If you shared with law enforcement, could law enforcement go to that house and maybe enforce a red flag law, or see if they had handguns, or see if they had, what could they do, or what do you envision law enforcement doing with the information? Beyond telling the school resource officer, keep an eye on Monty.
Delegate Adams.
Senator Favola and Senator Mason, I would certainly be interested to hear other instances that the sheriffs may have in mind. My particular sheriff, he had mentioned that he knew that he could not even share that with a school resource officer to be on the lookout for someone. And I think that most of these cases, and correct me if I'm wrong, I do not serve on one of these, but most of the time, some of these youth are not in the school. They're not in the school system because, the problems that have led them to an expulsion or some sort of alternative programming already. It's just there may be a connection with the school, or they may be on some list of, hey, let's make sure this person isn't entering the building, or you're aware if they're on the premises. I think that those were the instances that came up to the discussion that prompted the legislation. There may be more that I'm not even contemplating here, but that would be one.
Senator Mason, and then Senator Servo, and then a few
Because
others.
it sounds great, right? But what are we doing? I mean, would your bill allow the law enforcement to go to a home and enforce a red flag law? The lady in my situation had just gone and legally purchased a firearm, which I am 100% advocate for. But because we don't have safe storage laws, there was no indication, hey, if you got a kid under 18, be careful. Supposedly put it on the top shelf of a closet, and the kid got to it, took it to school, and shot its teacher. So could the law enforcement, if they had that information, go to the home and say, do you have any firearms? We're concerned about your child. If so, we think we should, do something about that. Would that be a logical extension of your bill?
Well, Madam Chair, the bill does not contemplate that. It does not have anything beyond, whatever is already in place in terms of what predicates might be required before, say, an action on a red flag law or something like that is required. So no, I think the answer is no on that. And the other point I make is it's law enforcement and the threat assessment team that's already established under the code to deal with these situations.
Senator Servo, you said you had an amendment. I'd like to get that on the table.
Yeah, Madam Chairman, it relates to Senator Mason's question, and what I would suggest is that, I think it's at the end of line 27, just add, maybe David can clean this up for me if I'm inarticulate, but say, including an assessment as to whether or not such teams should request an order pursuant to Title 19.2, Chapter 9.2 of the Code of Virginia, which is the substantial risk orders subchapter or chapter of the code.
Let me ask David May to maybe polish that. Can you?
Madam Chairman, speaking to my motion, if
Speak to
somebody
your
would second
motion.
it.
Second.
As we heard during the discussion about the substantial risk orders, they're not being used in a lot of localities because a lot of people are not really aware of all the scenarios that they ought to be used for. There's about 50 or 60 localities in Virginia that hasn't sought one yet, and there's probably about a dozen or two that have only sought one. And part of the reason we passed other legislation this session was to try and make people more aware of what these should be used for and the scenarios in which they could be used. And if this is in the code, I think it will help people to think about, maybe this is something we ought to be looking at.
Let me ask Mr. May to repeat the amendment before I take other speakers, and then we're going to have to act on this bill. Mr. May.
Madam Chair, I guess my one question of clarification would be, is the intent to have the law enforcement agency or the threat assessment team who's receiving the information make that assessment, or is it the intent that the FAPT or CPMT?
Madam Chairman, Well, the intent under the SRO process, the law enforcement agency is the one that has to make the initial determination, and then they go consult with the Commonwealth Attorney after that if they think they want to pursue one. But it starts with the police department. That's the way the whole process starts.
So to be clear, they have that authority to do that anyways. This is just articulating it in this bill. Is that correct?
Yeah, that's right.
Okay. And I am fine with that amendment. Actually, Senator DeStep has had his hand up for a while.
Madam Chair, I was going to make another recommendation, but at this point, I'll defer. I think this is a good.
Moving in the right direction. Okay. Actually, I have to ask the patron, do you consider that to be a friendly amendment?
I'm not certain I do. It is certainly not my intention to, again, go beyond or to promote, say substantial risk orders or to encourage that, or that's not the objective here, to go beyond this, an additional remedy. I would say that'd be an additional remedy beyond just the allowance of certain information. I think as you articulated it, there's already remedies that can be made.
But I will say that not having a memorandum of understanding up front between the FAP team and the other teams with a court in advance with the guidelines on when information can be shared, which would make me feel better. The intent, I don't think anybody disagrees with the intent of this bill. Let's just be clear. We're just trying to balance a lot of different issues. Senator DeStef.
Madam Chair, and to the patron, I think that if we put the amendment on, pass it out of here, get it to the floor, there'll be an opportunity to throw this into conference after the patron has an opportunity to really digest this. We're still early on in the process, but it would at least move the ball forward. And then, give an opportunity for him to come up with another option. We still have the opportunity to I think the underlying intent of the bill is something that the committee itself wants to move forward with. We've shown that with the recommendation of trying to amend it, not trying to harm the bill or hurt the bill,
I think it is
move it down the process.
I will ask the patron.
Well, Madam Chair, if I may
It's your bill.
if I may respectfully offer a suggestion on just a rewording of the proposed amendment, wherein it would, instead of addressing something specific like substantial risk orders, would instead require, say, if the locality has adopted a to the point you made, Madam Chair, if the locality has adopted a memorandum of understanding with the threat assessment team or something like that to say about potential remedies upon the sharing of such information.
That would hit the nail on the head if we could get that into words.
I would take that as a friendly amendment, yes.
Colleagues, what do you think about that? Because the Commission on Youth talked about having a memorandum of understanding between the localities and.
Madam Chair.
Yes.
So, we're not trying to do harm to you here. I mean, yesterday I had 4 amendments put on a bill that I didn't even know about and passed, all right? So I'm not trying to do that. But the point is, what you described sounds great, but if we're going to go down the path of removing the utter confidentiality of these proceedings, we need to have a memorandum of understanding in place. We need to maybe even reference the substantial risk order, just because there has to be something there for us to do it, right? I mean, just telling the school resource officer, to your point, sir, they may not even be in the schools.
I have a suggestion. I'm going to ask that this bill go by temporarily while we hear the rest of our docket. And then if you have something that you've heard the debate, if you could come back with something that may assuage some of the concerns.
Madam Chair.
We'll take a vote.
His suggestion, what he just got through saying, I like that. Could that?
Yes, he's got to work on the words.
Can we work on that? I like what he was saying.
Yes, and he did respond to that. I'm sorry I didn't bring up the memorandum of understanding earlier, but so why don't you go maybe with a brain trust in the corner, see what you can come up with. We've got 2 more bills to think about, and then we'll come back to you.
Okay, thank you, Madam Chair.
All right. let's move on, and I think Senator Morrissey, don't go, oh, you wanted to go help. Go help. All right, and we'll do, because I do have a bill that will affect your, why don't we go to patron, Delegate Freitas. Is Delegate Freitas?
Thank you, Madam Chair. I apologize for being late. We were conforming your bill. So.
Oh, lovely. Why don't we go to House Bill 1881? Yeah, you were thinking about me anyways, huh?
So, Madam Chair, fairly straightforward here. What we're attempting to do, and you can see on line 49, we're trying to keep, this deals now with just industrial hemp. Originally, this was a much broader bill. It's been significantly pared down to just deal with industrial hemp, and there's two major things that we're trying to do. One is we're adjusting the fee down to $250, so no fee or registration or renewal set by the commissioner pursuant to this chapter shall exceed $250. And then we're simply directing the commissioner to not grant, suspend, or revoke any registration for growing and dealing or processing industrial hemp or hemp products in a manner that allows for the creation of monopoly. So one of the biggest concerns that we've had as we've talked about everything from kind of cannabis as a broader category to industrial hemp is, are we going to set up a regulatory or tax environment which essentially crowds out any of the potentially smaller producers that are still operating within the law, are still operating in good faith, but because of registration fees or other policies, it makes it impossible for them to compete with the big guys. And so this is just an attempt to make sure that as we go through this process, and this specifically just for hemp products, we're making sure that the fees are reasonable and that we're not encouraging monopolistic privileges or tendencies, and be happy to answer any questions from the committee.
Yeah, I guess my understanding is that there really would not be any opportunity to revoke a license. I mean, is that a clear reading, Mr. May?
Sorry. Madam Chair, yeah, I guess what the language to me reads, it says that in the context of revocation, the commissioner would not be permitted to revoke a registration for growing, dealing, or processing if it would either create a monopoly or lessen competition.
There could be other reasons that might override the need for a monopoly. What if a licensee wasn't meeting public health standards or?
Madam Chair, if I could speak to that
Yes,
briefly.
Delegate.
So obviously if someone still violated the law or violated policy, they could still have their license revoked. If there is concern with respect to the language being overly broad, and I'm assuming we're talking about line 52, after the word monopoly, it says, or otherwise lessens competition in industrial hemp. I apologize, I do have a substitute, or excuse me, an amendment. And what that would do is after the word monopoly on line 52, it would strike or, and then the rest of line 53 all the way to Commonwealth. And what that does is it takes out the language or otherwise lessens competition in the industrial hemp or hemp product industries of the Commonwealth. Because again, if that's too broad, and then what that does is it puts it in the posture of just saying, in a manner that allows for the creation of a monopoly. So I think that would be much more specific language, and I do have a copy of what that amendment would look like if that would be appropriate.
Are you moving that amendment?
I would, Madam Chair.
Okay, may I have a motion to move the amendment and accept? Okay, motion has been made and seconded. All those in favor of accepting the amendment signify by saying aye. Aye. Okay. All right, colleagues, are you clear on the amendment? Okay. Why don't we, discussions with the committee? Is there a motion here?
Move the report. Second.
Motion has been made and seconded to report. All those in favor signify by saying aye. On the board, please.
Ayes 8, noes 4, 3 abstentions.
Ayes 8, no 4, 3 abstentions. Your bill reports.
Thank you very much, Madam Chair. Members of the committee.
Okay, so Senator Morrissey, you have to be here. I'm not going to call you. I'm going to call Delegate Williams, but
Good morning.
You had a similar bill, and Senator Obenshain had a similar bill to the bill that Delegate Williams is going to present, as I understand it. We should turn to House Bill 2169.
You're correct, Madam Chair. I had Senate Bill 1361. Both the delegates and my bills were parole transparency bills. So I'm going to move to conform Delegate Williams' HB 2169 to my SB 1361.
I'm just going to ask Mr. May, is that in order? I mean, the bills are not exactly on all the same topics, but there are there's some overlap.
I can give you the similarities or differences after.
Go ahead, Mr. May.
Madam Chair, yeah, I mean, the bills are generally about the same topic. I think Senator Morrissey's prepared to, and I've got some notes on some of the differences. They do have many different provisions in them, but like I said, they are generally both about parole reports and the granting of parole. I'll defer to the committee on decision.
Madam Chair.
Okay. Senator Sproul, and then was it Senator Servo?
We sit here talking about together. I would like to at least hear the patron say that, yes, he liked the idea. Say something, you know.
A motion.
I didn't want to interrupt.
You always kill my bills, but say something.
Okay, all right, we're getting to that, Senator Sproul.
Would you let him say something?
So I'm going to ask the patron, a motion has been made to basically conform your bill to Senator Morrissey's bill, and that would put you into conference. Is that acceptable?
Yes.
Okay, motion has been made.
Well said, well stated.
All those in favor of conforming the delegate's bill to Senator Morrissey's bill signify by saying aye.
Aye.
Move to report.
Madam Chairman, a quick
Well, let's
question.
just hear some speakers. Senator Servo, and then we're going to hear a few speakers.
So what's the number of Senator Morrissey's bill?
1361.
1361. Okay. So I guess I have a question for the patron.
Senator Servo.
Doug Williams. So one of the things that I guess is in play in all this is it appears that in your bill, the one we just replaced, it talks about publishing the reasons, or publishing each case where parole was granted and the votes of each member, I think, right? Can the patron think of any reason why we ought to not also publish the votes of each member when parole is denied? Right now, you can only obtain that by FOIA.
I think
Let me address this, Mr. Chair, Madam Chair. I tried to do this a few minutes ago. Let's just talk about the similarities, okay? First of all, my bill was already conformed in courts of justice to the delegate's bill. Similarities. The Virginia Parole Board will publish actions more frequently. Number two, the Virginia Parole Board will hold public hearings, including public votes, and Senator Servo. Number three, actions taken by the Virginia Parole Board, including granting parole or denial, will require written explanations. Those are the similarities. The differences, I believe that Delegate Williams has a provision in his bill that provides all investigatory material goes to an inmate and his attorney. Good idea. I thought mine had it in one iteration. Great idea. Let's not overthink this. Again, we've got nearly identical bills. My bill has already been conformed to his. We conform it to the others. And if we have one or two little items that we got to fix, we'll do that in conference.
Madam Chairman.
Okay, Senator Servo, and then I'm going to take the speakers. Senator Servo.
I'd still like Doug Williams to answer the question I asked.
Can you repeat the question?
My question was, this bill, your bill, talked about publishing the votes of members when parole is granted. My question was, wouldn't you also agree that we also ought to publish the votes when parole is denied?
I'd defer to Senator Morrissey.
I want to hear it from him, not you.
Okay, no, we want to hear from the patron, and then we're going to take brief comments.
I don't have any reason to say or to stop sharing why something would be denied. That's fine.
Madam Chairman.
Senator Servo.
The only reason I ask is because right now you can only obtain those votes under the Freedom of Information Act. And it seems to me that if we're going to put out all the votes when parole is granted, we also ought to put out all the reasons when parole is denied. We ought to have it both ways and not just one way.
Yeah,
Does that make sense to you?
Yes.
Okay,
Okay,
very
thank
good.
you.
Let me hear from the speakers, because your bill's already conformed. We still have to report it out. Gentlemen, did you want to come forward to speak?
Just very briefly, Madam Chairman, Chad Dotson, Chair of the Virginia Parole Board, and the administration does support this bill, but I do also believe that we believe it can be conformed in a fashion that the administration would
Madam
support as
Chair.
well.
Senator Morrissey?
Mr. Chairman, one of the issues, and you heard my colleague Senator Servo said it, there needs to be a more robust explanation from the parole board when it's denied, other than the normal because of the facts and circumstances. Do you also agree with the delegate and me and Senator Servo that a more robust explanation for denial is appropriate?
I think that I think that's a best practice for any parole system, so yes.
Thank you.
Okay, thank you, Mr. Morrissey. Sean?
Good morning, Madam Chair, members of the committee. Sean Wineta speaking on behalf of the ACLU of Virginia. We worked really hard on Senator Morrissey's bill with a lot of stakeholders, including Americans for Prosperity and Prison Fellowship, and we support the bill as conformed. Thank you.
Okay, so colleagues, I'd like a motion to report the bill as amended.
Move report.
His motion's been made and seconded. Will the clerk please open the roll?
Ayes 11, noes 3, 1 abstention.
Thank y'all.
Okay, now I wonder how the Brain Trust is doing with the previous bill. Is the Brain Trust back? Okay. Delegate Adams, do you have something that maybe addresses the concerns?
I believe so, Madam
Good.
Chair, and I was
Colleagues?
And I was
We
just,
have an amendment before us. Again, House Bill 2018.
and I was just sharing this with your staff to, and certainly welcome his comments. But it would be on line 26. Maybe it helps just to read the entire sentence. If the team, starting with line 25, if the team obtain information from which the team determines that a child poses a threat of violence or physical harm to himself or others, the team may, and then we added comma, in accordance with terms included in a memorandum of understanding between the team and local law enforcement, comma, share such information.
I'm much more comfortable with that.
Okay.
That does it for me.
Madam Chair.
Senator Mason.
So just complete avoidance of any red flag, any substantial order. I mean, what you're proposing here, I get the concept, is super dangerous. It is, I mean, these are ultra confidential discussions. And so I know the administration sent Scott over here to say he supports the bill, but I'll bet you, looking at the professionals I'm looking at right now, if they pulled you aside on their own, they'd say, man, this scares the heck out of me. So I just, if we're doing it, sir, we really, really, really need to button it up and make sure that it has some heft to it.
Which would be adding another sentence about
Because this is something that, like I said, I'm a rookie at this. But in 5 or 6 years of working on this stuff, this is a whole new step. This is a big, hairy deal.
But point well taken, Senator Mason. I would just like to ask, for purposes of clarification, in the MOU, couldn't there be language about actions that the law enforcement would then be able to take?
Yeah, absolutely, Madam Chair.
So this could be contained in the MOU. So my concern was that there be some guidelines around what was an imminent threat, how much information, in fact, would be shared, where it would be contained, and then what law enforcement would do.
Madam
and
Chair.
I think that MOU provides that framework.
Madam
Senator Sproul.
Do we need to accept the amendment or not?
We need to accept the amendment. We're still discussing. Senator Rouse.
I so move the amendment.
Madam Chairman, my motion never got acted on, which is the first motion to amend. But
Okay. We never acted on yours. So
I know,
it's
still-
not on the table.
it is on the table. It never got voted one way or the other.
Can we hear where we are?
Okay.
I'm sorry.
Okay, colleagues, we have the bill unamended before us. Senator Serval had offered an amendment which the delegate had rejected. The amendment was adding information on a substantial risk.
Right.
So we could force the amendment on the delegate if that is your wish.
All right, so they went out and talked.
They went out and
Can we
talked.
please understand what they came back with?
Did you discuss Senator Servell's amendment?
Yes.
Okay, could you tell us what your conclusion was?
Well, the conclusion was to avoid a specific reference to substantial risk orders.
Okay.
As initially
All right.
indicated.
Okay, now, Senator Servell, are you insisting on that amendment? The committee can certainly do that.
May we
Senator
hear what
Mason?
they came back with, Madam Chair?
He just
I
read
think
it.
we did, okay?
Okay, may I hear it again?
You may hear it again. He did say it once. Delegate Adams, what is your requested amendment at this time?
So, Madam Chair, after consulting with the administration official and sheriff's representative, on line 26, after the word may, comma, in accordance with terms included in a memorandum of understanding between the team and local law enforcement, comma,
And that,
share.
did that satisfy Ms. LaRue from the Virginia Poverty Law Center and the others who were working with you? Did not.
No, she indicates that she'd feel more comfortable with a procedure whereby petitions were required to go to the court and seek some sort of court order.
I will say the MOU idea did come out of the Commission on Youth a few years ago, which we were not able to move forward. So again, Senator Servell's motion is before us. It is different than the amendment that was offered by Delegate Adams.
Madam Chairman.
Senator Servell.
It strikes me that there's probably more work that needs to be done on this bill, and I think my amendment on the bill would probably put this in a context where it'll probably go to conference and we'll have another probably 8 or 9 days to discuss figuring this out. And I think that's probably the better way to proceed at this point, because I think Delegate Adams may be onto a good idea here, but I think it's going to take some more discussion and work and language with all the stakeholders to get to home plate. I think there's a desire to do that, but I think my amendment would get us to home plate eventually.
Would you, may I ask you to amend your amendment to also accept in accordance with the terms of an MOU, so your amendment has 2 clauses in it?
Sure.
Okay. All right, colleagues, the amendment before us has 2 clauses, and I'll ask David May to read them. I'll read them. I'll read them if you want.
Could I hand him the notice?
Madam Chair, I'll probably have to dice this language up a little bit upstairs, but essentially, the way I understand it, we would put in, whether it be the same sentence or in a separate sentence, I'm not sure it'll be readable at this point if we put it all in one, to require that the local law enforcement conduct an assessment regarding whether a petition should be filed for a substantial risk order, and require that when information is shared with law enforcement, that it be done in accordance with the MOU. And I think we would have to change it slightly from the way the delegate pitched it, because unless it's the committee's intention, we wouldn't want that to apply to information that is shared with the threat assessment team.
Yeah, we would. Okay, so that's the amendment before us. All those, motion has been made. I'm going to second the amendment, if I may. Or would you second it for me? Second. Oh, Monty seconded, so did Senator Hanger. Okay, all those in favor of the amendment signify by saying aye. Aye. Okay. Okay. The bill is amended, so now I need a vote to report the bill as amended.
So moved.
Second. Is there a second?
Second.
Okay, will the clerk please open the roll? I'm sorry, we need more coffee at this hour in the morning. Bill reports.
Ayes 13, no 0, 2 abstentions.
Thank you, Madam Chair.
Thank you.
Appreciate it. Members.
Madam Chairman.
Senator McDougal.
I heard Senator Serval reference 8 or 9 days. I just want to make clear that we do not have that many days, that we have 7 at the most, and if you want to have anything resolved, you better do it in 6. Because Cinderella's shoes will disappear.
Okay, colleagues, you've done great work. According to my notes, we have completed our docket. Is that correct? Mr. May?
That's correct, Madam Chair.
Thank you. Thank you, colleagues. Thank you. This is the last meeting of our session, and I will be giving you some small thank you, something.
Good job, Madam. Good job.
Thank you. Yeah. The committee shall rise.